Let's move on to next session. And it's my privilege to introduce Commander Mukesh Saini, Senior Advisor, Cybersecurity and Privacy. Commander, welcome on board. Thank you very much.
Thank you.
Yes. Let me take quickly 2 minutes to just introduce you, sir. Mr. Saini is a cybersecurity thought leader, veteran naval officer, specialist in communication and electronics warfare with more than 35 years of experience in information warfare, cybersecurity, and now, of course, privacy. He was the first National Information Security Coordinator at National Security Council Secretariat PMO. On retirement from the Navy, he joined Microsoft as the Chief Security Advisor and later Group IT Security Head for SL Group. Presently, he is a Senior Advisor on cybersecurity and privacy with multiple companies. I have privilege and pleasure in inviting him to deliver the keynote address on the topic Continued Relevance of ITA 2000 in Privacy Protection, which I strongly feel relevant to all of us at this point of time with the kind of, the situation what's going around, that the PDPB 2019 bill was withdrawn, and there is a myth probably that India does not hold a data protection law at this point of time. And hence, it's really significant and relevant for all of us at this stage to listen to his views. Mr. Commander Saini, floor is yours. Thanks once again. Please go ahead.
Thank you. Can you bring up the presentation?
Yes, Commander. It will be there.
Thank you, everybody. Good morning, good afternoon, good evening to everyone. I thank Navi and his team for let me speak to you people and share my thoughts on the continued relevance of Information Technology Act 2000 in the privacy protection. Next, please. So the question is, what is privacy? A lot of people have spoken about it. To me, privacy is far superior and internal to the people. Even I give you the example. Let's say somebody has a young boy has smoked, but he doesn't tell home, and his friends inform his mother that he smoked. Now, whether the smoking is good or bad for health is one part of the story, but second part of the story is his privacy is breached because he trusted his friends and friends have breached it. So privacy is not confidentiality. Privacy is beyond that, where the person who is involved in the privacy is the one who gets harmed. Next slide, please. So there is a definition of harm which is given. The interesting part of this definition is the adding of 2 more thoughts to it. Of course, that psychological manipulation which imparts the autonomy of an individual or other such harm as may be prescribed. So it left the government to take a call that how they prescribe the harm in the privacy. Now let's look at it. Next slide, please. And when we talk of data, it is not technical meaning of data. The PDP 2019 or DPA 2021. It is data is a representation of information, facts, concept, opinion, and instructions. It's not the standard wording of data which technologists know. So it covers anything and everything under the law, which is under the sun, which forms any kind of information. So that we must know. It is no more of physical bits and bytes. It's far beyond that. That's how the law is defining the data. Next, please. So we must know what is the difference between privacy and personal data. That's important because privacy is keeping information safe from those who can harm an individual, right? Whereas privacy control, is basically you trust somebody, you tell somebody. So in this particular case, you tell a company that you give your personal data, you give your Aadhaar card or you go give your PAN card, and you trust them. Now that trust can be implicit or explicit. But if that person ends up forwarding this information to unauthorized person, then there is a problem. To overcome this problem, the data protection laws are being built around the world, and the laws are enforcing this trust. Actually, this trust is getting enforced through the law. The question thus arises, do the advertisement harms if the information given? To some people, it is not, because they get the information, but it does. It creates nuisance. It impacts the decision-making process, that you end up getting infected by the advertisement. And do cyber fraud harms? Now, this is very interesting question, because recently we had Air India, where the data got leaked. We had Swiggy, data got leaked. We had large data got leaked in recent past. Does their share price came down? No. Does their number of the people using the services came down? No. Did it harm? Only for 2 days? 2 days it came in newspaper. That's it. Nothing beyond that. So no harm has been caused to them. So, and there's no law, so there's no impunity. But how an individual getting impacted is what we must understand. The data which has gone stolen and put in the public domain is now available with the group which are hackers, or with the people who collect this information. And when they carry out a fraud against you, when they carry a targeted fraud against you, which is generally today, most of the financial fraud are very targeted. They have a hell lot of information behind you, about you, collected from all these leakages. That what is your house number, what is your phone number, what you did, all this information, and that's how they're talking with the confidence with you, and that's why they successfully make fool out of you. So this information harms in entirely different manner, and these companies are not getting penalized because we still do not have any law. Now, from here on, I'll move reasonably fast because of short of time. So personal data protection is minor differences. Personal data protection just talk of natural person, is a subset of data protection, whereas data protection is focused on primarily on the malicious attack, breaches, and things like that, and deals with the subject of protecting the information, whether using antivirus, whether using XDR, MDR, any technical mean, or through the access control, or through the standards. Whereas the personal data is more to do with the governance and the business, and how it is collected, how it is getting processed, or where it is being passed. All these things are important, and if you want, is it getting deleted or not? When we move again, privacy versus confidentiality, there are clear differences between them. And important part is last line, where privacy is a right, but confidentiality is a contractual agreement, right? That's important difference we must understand. So question thus arises, does these bills, which is Personal Data Protection Bill 2019 or DPA 2021, are they answering the question which the Justice Puttaswamy judgment has raised, that this is a fundamental right? When we talk of fundamental right is only and only between the government and a citizen or a person in that country. It's nothing to do with company, it's nothing to do with other person. They're enforceable. Fundamental rights is very clear. Fundamental rights is given in Article 21, under which the Justice Puttaswamy judgment has been given, talks of only the relationship between the a citizen and or the person and the government who is governing him at that point of time. It doesn't deal even with the government which is not governing you at that point of time. It's only the government who is governing you at that point of time. When we look at these bills, under Section 35, they want to exempt those very organizations which are supposed to be under fundamental rights, right? Which are known to be breaching the fundamental rights. And if something is left, then Section 36 is a backup plan, where even if 35 strikes down, 36 will still provide the same kind of safeguard against breach of fundamental rights. So let's get very clear. PDP or data protection bills, both of them at present, which were shown to us till now, I don't know how the new one will look like. But if we go by this, do not protect fundamental rights. They deal only with the personal data protection given to the companies, given to anybody, any person. They deal with any person, that's it. Not even an individual, not natural person, any other person. It covers only that much. So let's look at, is the IT Act, which is Information Technology Act, is the root of the privacy protection. Is it? Yes, it is. And that's very, very important part to know, because Information Technology Act is given legal recognition to all transactions done in electronic mode, right? Under Section 4, which is my friend Pawan Duggal also spoke, given legal recognition to electronic records. So it your personal data, private data, when it comes into computerized form, it gets covered under Section 4 of IT Act. Similarly, Section 7 of IT Act is talks of retention of electronic record, where when to delete, when to modify, all these things get covered under Section 7, also comes into force along with the retention part. When we say Section 78, it allows the auditing of the document. So when the authority, whosoever, whether we created DPA or whether we get PDPA, whosoever authority or get created, will able to audit. And when that audit is come, not only PDP, the empowerment of that comes from the core at the root is from Section 7A of the IT Act. Next. Sorry, I'm moving on my system. Next. Next.
Commander Saini,
I'm
kindly tell him when you move on to the next slide. I realized it actually.
Yeah. Next, please. Next, please. Next, please. Okay, next, please. Yeah, I spoke of the objective. Now, next, please. Section 4, which is of the making the legal recognition. Next, please. I'm here. The Section 7, which says audit of documents and to maintain electronic form. So this empowers the data protection authorities to undertake the audit. Next, please. So when you say click yes, and when you interact with any entity, any person, then you are actually entering into contract. If you read the basics of the PDPA 2019 bill or the Data Protection Act 2021 draft 1, they both talk of contract act. Okay, so it is a contract, and Section 10A covers the IT Act. Section 10A covers that part. So it is. So remember that this is a mapping. This mapping is taking place, and until unless this particular act is not providing the support to the DPA or PDPA, whichever is come, it will have impact. Similarly, attribution of electronic record. Who is the one? Am I sent it the record? Did I send my personal data to you or somebody else's personal data to you? Whom to attribute to it to? This will be covered in Section 11 of Information Technology Act. Then we come to Section 13. Next, please. The Section 10A. And next, please. Okay, Section 11. So Section 11 talks of, attribution part. Whom the electronic record will be attributed to. When this is passed, where it is passed, whom it is passed, it will come under the IT Act again. Next, please. Okay, Section 13 is time and place of dispatch and receipt of electronic record. It is important to note that when you click sign the consent form, the consent is counted when. It sounds ridiculous in this fast bandwidth area, but remember, complete world is not connected to the fast bandwidth. You may have delays taking place, and if the delay is taking place, then when it contract amount to get signed, and if anything happened before or after that, will be a legal matter, right? So when the legal matter comes, then Section 13 of the IT Act will come into play. Next, please. So if we leave Section 13 again. Next. Yeah. Basically, I want to talk to the complete process of dispatch of electronic record is important. When it gets signed, when it got clicked, this has to be recorded at the receiving end. That's the time, not the person when is clicking. And that legality, when legality will get fought at some stage in future, this Section 13 will be an important pointer that what is to be counted as the time of signing of that contract, when the record is given or agreement is given or consent is given, or when any email is sent, things like that. Next, please. Next, please. One more. Okay. Section 43A, which is presently controlling the privacy or personal data, which is basically nothing but a ditto copy of the safe haven. Okay. If you look at the rules is a copy of the safe haven law, which is abolished immediately. By the time we brought this law into force, the European Union has removed the safe haven from the list. In any case, both the proposed laws says that this will be replaced by the law. So remember, what is important to understand is that the bill is going to replace only one section of IT Act. Remaining all will stay back and will support. And without them, the personal data protection will be incomplete. Next, please. All the offenses mentioned in Chapter 11 and all the actions by intermediaries, which are basically social media primarily, will be covered by Chapter 11 and 12, right? So that is important that these get covered under that, and offenses will be there. Remember, in the section, in the both the bills which have been withdrawn, there is no offenses. There is no offenses except one, which is quite ridiculous kind of offense, but that's what it is. One offense has been made, and it is in circles. That law is very, very, very poorly drafted, right? But all offenses which will actually lead to offenses, when we say, is means which may lead to a jail term, is covered under the IT Act. So IT Act will come into play where the criminality get committed under the DPA. So criminality of that will be covered under IT Act, right? If it is civil law, then you can go to that. But if criminality has to come under this. Next, please. And Section 72 stays, which says penalty of breach of confidentiality and privacy, which you can use even today to some extent, and initiate a legal case. And it does provide certain amount of processes, which is feasible. And because there is a processes associated with the procedure associated with it, to some extent, it do provide some kind of fundamental right safeguard, which is not there, by the way, in both the bills, as I mentioned earlier. Bill doesn't have it. Next, please. And through schedule, the various other laws have been modified. Most importantly, Indian Evidence Act has been modified. And in that opinion of electronic examiner, so finally it will come down to, when the matter comes down to court, electronic records has to be preserved according to Evidence Act, which has been modified by the IT Act. So I am saying the IT Act is continue to stay at the root of the data protection law, whichever form it may come in, right? Whether admissibility law is there, whether presumption of electronic agreement is there, or any means, emails are there, WhatsApps are there, they're all covered under IT Act, through IT Act, in fact, the Evidence Act, right? Next, please. Now comes to certain directions. Certain direction, important part is that we have to report the incident within 6 hours, which Navi was mentioned in earlier session, is that 6 hours is controlled by Section 85 of the IT Act. 85 IT Act says, just hold. 85 of IT Act says that 72. Just go, please. So Section 85 of IT Act says very clearly that when it comes to knowledge of, awareness of the management, they listed out the management clearly later. When it comes to knowledge and they become conscious of the fact, which now very clearly pointed out, when they become aware that yes, there's a breach has taken place, that's the time the 6 hours starts. But within that 6 hours, they have to take a call, whether it is worth reporting or whether they are obligatory to report to the certain, or is it a internal problem somewhere else. That call has to be made within the 6 hours and matter has to be reported. Next, please. So there are going to be 3 different regulators coming into play. Now, how they're going to coordinate between them is going to be another issue. And considering that personal data protection going to protect our 1.4 billion people is not going to be easy task by single regulator. They probably may have to create the various benches across the country, but that's how it will be. Thank you. That's all I have. I again repeat that IT Act will continue to form the basis. Next, please. Continue to form the basis of any, whether the Data Protection Act comes about or the Personal Data Protection, whatever form it comes, will come in that form. Next, please. Thank you. Yeah.
Great.
I try to hurry up and try to meet the time. Yeah.
I understand. Yeah. Thank you very much, Commander. Really appreciate your sharing your thoughts in a way. all easy to cover, so vast subject in this half an hour. But I think the main important bullets what you had covered, and that message is very loud and clear that yes, we do have the data protection law in India at this point in form of Section 43 capital A of our IT Act, correct? And you also touched upon Section 67C to Section 72A and etc. Really, I would like to thank on behalf of FDPPI and on behalf of everybody who is attending the session. And thanks once again, and have a nice evening. Thanks for sharing your time.
Thank you. Thanks.
Great.
Thanks for
Yeah.
opportunity. Thanks.
Thank you very much.